support of the complaint that there is a reasonable ground for the complainant, court is given powers to give award and so on and so forth. The gist of the matter, my lord, is about court being satisfied that a person before court is detained without lawful orders. My lord, these facts are brought out in the affidavit.
Before you proceed, I think the AG or the representative can you formally be on record? Or if I have seen badly, then you can.
So, brother,
the microphone says you can speak from there, but we have many lawyers.
Your Lordship, I'm not surprised. My name is Johnson Natwera. I'm a senior state attorney. Together with Matthew Hesse, a state attorney, and Jacqueline Amsugut, a state attorney. Yes. Your Lordship, we are sorry we are late because this matter was served on us late, and we had to ensure that we respond. We have filed our response to the indictments, and we are ready to proceed.
My lord, on my part, I think 10 minutes would be enough, and then my colleagues will also come in, my lord. My lord, it's our prayer that you be pleased to find that Dr. Besigye and Obedi Rutare are in illegal incarceration, given the fact that, my lord, there is no evidence before you that there is any charge preferred against them, or that there is any remand warrant being issued by any court, or any lawful order given by court for the authorities in Ruzira to keep them in custody. My lord, the affidavits which are borne out, the facts which are borne out in the affidavit of the Honorable Winnie Byanyima, as well as Counsel Proscovia Kunihira, are uncontroverted. There is no any evidence from the respondents, that is the Attorney General, and Act Cap 325, a person shall not be received or admitted into prison custody without a valid commitment or remand warrant, or order of detention, warrant of conviction, or committal. So that is the law, my lord. And now, my lord, the essence of habeas corpus is well explained in the decision of this honorable court in miscellaneous cause number 16 of 2021. Honorable Chagulanyi Sentamu Robert, Babula Chagulanyi Tungo versus the Attorney General and the Chief of the Defense Forces. On page 14, my lord, a copy of which is going to be supplied to court. Page 14, this honorable court had the occasion to succinctly explain the essence of the writ of habeas corpus in the following terms. The purpose for a writ of habeas corpus ad subjudiendum is to review the legality of the applicant's arrest, imprisonment, and detention, and challenge the authority of the prisoner or jail warden to continue holding the applicant. The application is used when a person is held without charges or is denied due process.
Can we stop there, please?
Yes.
How did they end up in prison in the first place?
My Lord, that is for the Attorney General and the Commissioner of Prisons to explain by way of evidence.
So for you, you have no idea.
My Lord, I will explain. My Lord, initially there were charges that had been preferred against them as explained in the affidavit of Winnie Lyanyima and Proskovia Konihira. My Lord, that is well explained. If I may go there, my Lord, to read the relevant paragraphs. The explanation is that, my Lord, the defunct General Court Martial had preferred the charges against them, and on the 31st day of January, my Lord, this year 2025, the Supreme Court unequivocally pronounced itself on the constitutionality of the proceedings before the General Court Martial.
Remove the handicaps. Remove the handicaps. Freedom for Aaron. Aaron, the conqueror of the court martial.
Yes, my Lord. What happened, my Lord? All the proceedings before the General Court Martial were quashed by the Constitutional Court, and my Lord, the decree to that effect was extracted. My Lord, I'm sure it's on record, my Lord. Yes, my Lord, we can, if I may be granted more time from the 10 minutes I had earlier requested for, because I thought court had abreast itself with these matters, my Lord. My Lord, it is hereby ordered that the declaration of the Constitutional Court that Section 119, subsection 1G, now Section 117 of the UPDF Act, which provides that any person not otherwise subject to military law who aids or abets a person subject to military law in the commission of a service offense is unconstitutional, so that order is hereby set aside.
Now, in one
Two,
in one line, what is that paragraph stating for our meeting?
my Lord, initially the Constitutional Court had held that section 119, which is now 117, that had provided for a situation where civilians would be subject to military law if they abetted the commission of an offense by a serving officer, that was a valid law. They had not nullified those provisions. Now, that order of the Constitutional Court was set aside by the Supreme Court, meaning that Section 117 has now been nullified by the Constitutional Court. All charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with the competent jurisdiction. 3. Yes. All charges, my lord, all charges, these charges are preferred by the DPP under Section 100, Article 120 of the Constitution. The charges before the General Court Martial are not sanctioned by the DPP. So the charges to be taken or transferred to the civilian courts pursuant to this particular order are those ones sanctioned by the DPP. As we speak right now, there is none, my lord. There is no charge sanctioned by the DPP to be taken to the civilian court.
So, but in this sense, the decree indicates that there is a certain court, not the civil court, not the civil thing. Is that how I understand it?
That they can, yes. Habeas corpus addis abduciendum, we are in the right forum, my lord. Yes. This judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in a court of law. And this is not applicable to the applicants because they are not convicts. And finally, my lord, no, the second last one. All pending trials or partly hard criminal cases that fall under the civil law court's jurisdiction, which are against members of the UPDF who are subject to service law, must be transferred to the civil courts with competent jurisdiction. It is also not applicable for the serving members of UPDF. 5. Save for the issue of the establishment of the General Court Martial as a court of law, this appeal fails and is hereby dismissed. That is. My lord, it is, as far as the matter before you is concerned, it's paragraph 1. Only paragraph 1, where, all right, my lord. My lord, the submission is that following this declaration or pronouncement by the Supreme Court, the proceedings hitherto pending before the General Court Martial under Section 117 of the UPDF Act became a nullity. They were quashed, and there are no proceedings pending against the accused persons. And that brings us within the realm of the prerogative order of the writ of habeas corpus. We have already cited Section 57 of the Prisons Act, and also now the Section 38 of the Judicature Act. And now we are addressing you on the issue of curtailment of liberty and the remedy that court is enjoined to grant. No, my lord, we are given the nature of this matter, my lord, and the circumstances concerning the dire state of our client, particularly Dr. Kiza Besigye, his health status, we deemed it imperative that my lord.
His condition has improved.
No. For 3 minutes, my lord. Most obliged, my lord. My lord, I've already addressed you on the question of liberty under the authority of Kyagulanyi and the Babla Itungo. One aspect which I needed to point out in this particular authority, still on page 14, liberty is defined by Black Law Dictionary, freedom from arbitrary or undue external restraint, especially by government. And this is, my lord, the import of the spirit of Article 23 of the Constitution, which guarantees liberty of Dr. Kizza Besigye and Obedi Lutale. In this particular case, my lord, under Article 23, first of all, they have not been informed of any offense under which they are, which they may have committed, and the reason why they are in Iruzira, and there is none. Two, my lord, Dr. Besigye has no access to a personal doctor right now for proper medical examination. And that is a very serious matter, my lord, because in as much as by a cursory look here, court can make one observation that maybe is improving. My lord, his state, the circumstances compel that an order be issued for Dr. Besigye to regain his liberty, to be able to access a medical facility of his choice so that he can be thoroughly examined to assess his health situation and get proper or specialized treatment. My lord, the final authority I would like to cite on this one is Chwanka John and others versus the DP Director General of Internal Security Organization. It is miscellaneous cause number 9 of 2021, where again this honorable court decided that a writ of habeas corpus applies in cases of illegal detention and is meant to secure the personal liberty of a person under such illegal detention upon determination of the validity of such detention by the court granting the writ. I agree with the counsel for the applicant that preservation of personal liberty is crucial and should only be derogated from in exceptional circumstances where there are court orders. And that is the position of the law. So this particular law, my lord, is reinforced by Section 15 of the Human Rights Enforcement Act. My lord, this is where we are grounding our prayer. Section 15 of the Human Rights Enforcement Act of 2019. Most obliged. Most obliged. Let me not go there, my lord. Let me sum up, my lord, my submission under Section 38. My lord, it's our humble prayer. Now that the Attorney General and the Commissioner General have not in any way attempted to justify the incarceration of Dr. Kizza Besigye and Obedi Lutale, my lord, you be pleased to order for their unconditional release, and specifically for Dr. Kizza Besigye to be able to access a medical facility of his choice so that he can be attended to by physicians of his choice. This is the prayer, my lord, that the order be made today and now, under the circumstances. And that's what a writ of habeas corpus is all about. Any continued detention, my lord, would be again a further violation. And we wouldn't want to see this honorable court acquiescing in the violation of the rights of the accused person. And for one thing I need to emphasize, my lord, there is the 48-hour rule, which is very, very crucial and imperative under the Bill of Rights. So you can only curtail one's liberty within that period of only 48 hours. And to date, since 31st, Dr. Besigye, Obedi Lutale have not been taken to any court to face any fresh charges whatsoever. So we pray that, my lord, you be pleased to invoke the powers here, grant the prerogative writs, and have Dr. Besigye and Obedi Lutale released. We do so pray, my lord.
Thank you for the courtesy, my lord. My lord, maybe to just make two very simple points. It appears that this writ and the matter before you is being constructed around the decision of the Supreme Court. But before we even arrive at the decision of the Supreme Court, I think there are two simple points that must be made. Personal liberty can only be curtailed on the basis of some lawful order. That lawful order cannot be verbal. It must be documented. It must be demonstrable. Otherwise, the curtailment of that liberty is unlawful. And because of that problem, the unlawfulness of it, that's why we have this writ in Article 44 as non-derogable. This writ has not always existed. In the 1962 Constitution, it wasn't there. But from the case of Besigye was 1966. It was recognized as a common law writ. It then came into the 1967 Constitution thereafter and was maintained into the 95 Constitution. But it has two limbs. One has been satisfied. And perhaps the most common one that has been satisfied is that the person has appeared here. But like Ibinjira's case, it was known where Grace Ibinjira was being kept. It wasn't a case of, the common thing where people sort of disappear in courts. It was known where he was. Just like it is known where these applicants are. In fact, we need not say much because when they came here, they were in the company of other officers of the state who have a unique attire. So we were able to tell that they are in custody. So we knew where they were. So the first limb has been satisfied, and that limb is bring the body. Sometimes we stretch it to whether dead or alive. The body is here alive. The applicant's came. But the second limb is what my learned friend has been addressing the court on. The reason for curtailing the liberty of those individuals. My Lord, the Supreme Court did not say that those who are incarcerated should remain incarcerated, except for those who had been convicted. One might argue,
for example, I was thinking we needed to consolidate these two applications. So you are saying for our friend Kevin Giza, since he was convicted. So the thing
that case is actually different, and you will note when it comes up, it is a completely different thing. Those who had been convicted, unless they are not challenging
Unless
the conviction. I believe my learned friend is very vigorously challenging the conviction. So there is nowhere in the judgment where it was said those who are in detention stay there until such a time that the government decides that it will find a competent court and transfer those files to that. So this application is brought with that idea, my Lord, with that argument in mind.
I wish we can get a chair for the aid itself. They need to write some of it. We can't write to study.
does this immediate extend to this other place? This immediate, doesn't it extend to this?
Private lawyers have taken over all the
If you want to read, Besigye is not the one supposed to prove that he deserves it, but it is them who are supposed to prove that.
Private lawyer. You're not private lawyer. You're your officer.
So my lord, one of the orders that was read is that these trials cease and be transferred. In there, they could have added, cease, the detainees remain in custody until the cases are transferred. They did not do so, and they were wise not to do so, because they had just pronounced themselves on the illegality of the basis of those charges before the court martial. So, my lord, as we speak, there are no charges pending anywhere in Uganda or elsewhere, apart from a case in Buganda Road on which the first applicant is on bail. His bail is being extended, but he goes back to another location, not to his home. That is the only one that is pending. But in that one, his liberty was given back to him. My lord, the burden to justify the reason for detention, for curtailing personal liberty, is not on the one who is applying. My lord, you can see that the affidavit was not even sworn by the one applying. The burden is not on the one applying. The burden is on the state. The state has replied. I'm going to address what it has said. There are two aspects involving the state, or two places where the state would have responded, in my view. One, the prisons officers would have brought before this court a warrant saying Court X on date Y told us to keep the body of these individuals until we go back. I have not seen it in the response. The second possibility would have been that they are pending charges, and this is the charge sheet. My lord, those pending charges can't come from the court martial. Because, my lord, some of the offences in the UPDF Act can't be tried in the civilian courts. There are offences there that are of a very different character, and they don't exist in the penal code. They can't be tried in these normal civilian courts. So they would have brought a charge sheet which says, you know, in court X, they are pending charges. This is the reason why these people are in prison. What do they refer to? They refer to the Supreme Court decision, which did not say keep them in custody. So I want to submit, my lord, and I hope that you will be persuaded that the response from the Attorney General falls short of justifying the reason for denying the applicants their personal liberty. Since the 31st of January 2025, it says nothing to you, my Lord, that explains why the liberty is curtailed. It only says the Supreme Court said transfer this. But as I have shown you, some of these offences, my Lord, cannot in fact be transferred. But that may not be a matter for us to address here. But they can't be transferred. So it is our contention, my Lord, that a proper case has been made out by the applicants for this court, which is clothed with that power. My Lord, the power is unfettered. It is so unfettered it can be applied immediately, clothed with the power to order the release of these applicants today. If the state has a lawful reason, let it act lawfully after those orders have been given, to then deal with the issue, whatever the issue that it has. My Lord, my learned friend has made reference to Section 15 of the Human Rights Enforcement Act. I am aware, my Lord, you are perfectly familiar with that space, and I very respectfully urge you, my Lord, to find merit in this application and to grant the orders that are being sought. My Lord, my learned friend, Honorable Segona, he wants to just wrap it up in a few minutes. Thank you, my Lord.
Except that I request that your case are obstructing view of my body language. We were told that you need to. My Lord, just to sum up, Section 57, which has been cited by my learned friend, Honorable Elias Lukwago, is instructive. A prison's officer can only detain on a valid warrant issued by a competent authority, in this case, court. Upon the demise of the General Court Martial, it is very clear that the power of the General Court Martial to order detention collapsed. And it collapsed in the presence of the Attorney General of the Republic of Uganda, who is the first respondent in this application. Whereas it is urged by the first respondent in the affidavit of Mr. George Karemera, paragraph 9, that the Supreme Court did not order release, there was actually no necessity to order release.
So, yeah, on that point.
Yes, my Lord.
So you are trying to read in some words in the decree.
No, my Lord.
You say it was not necessary, but it said so in so many words. You are reading in.
I am not even wanting to go there. I am only restating the position of the Constitution. Under the Constitution, liberty is guaranteed. Restriction must be justified, and that justification must be a lawful one. And in this particular case, the lawfulness would only be cemented on on a valid order of a court with competent jurisdiction. In the absence of it, there is no justification, and it is your power, my Lord, and duty to order freedom to be reinstated. Away from the Prisons Act, my Lord. Yes.
The Lord Mayor, my former teacher, are putting me under some weight that I should do it now. But I need to write it. How do I write it?
My Lord?
Can you address that?
Yes.
I can write it
Yes, my Lord.
hours?
Yes, my Lord, now is contextual. And what we are saying by now is that upon conclusion of our submissions, the court be pleased to begin writing the release order. In the same realm of context, my lord, I now propose to take you to the context of the Supreme Court's order of transfer, which has been misconstrued. My lord, this must be looked at from the perspective of Article 120 of the Constitution. The Supreme Court did not order the Director of Public Prosecutions to take over, because that is barred by the Constitution, Article 120. In effect, the Supreme Court told the first respondent, if he's interested in any prosecution, to go and start de novo. Do a fresh investigation, a fresh complaint. What one would expect is the state to report to the nearest police station or post and report and start with the first information. Why? Because any warrant of court has an expiry date and tenure. Thank you. My lord, with your permission, and I'm grateful, because the DPP cannot take over, the transfer order must be contextualized to mean, if you are interested, start a fresh complaint system. Go to the nearest police, report that these people are alleged to have committed offenses X. And when you do that, the DPP looks at the file, because the DPP even has the power to say, this one does not merit, and drop it at that stage. I was taking you on the point that a warrant or detention order itself has a time limit. Bring back this person on this particular date. That is axiomatic. And the moment it expires, lawfulness ceases. In this particular case, the warrant of the defunct court-martial was actually in itself expiring on the 3rd day of February. They could not extend or even terminate because they had ceased to exist. And since that time, the lawfulness, if at least it had not collapsed on the 31st day of January, died or redied on 3rd. My lord, to contextualize Article 120 and the decision of the Supreme Court, I would implore you, and we shall supply a copy, the decision of the East African Court of Appeal in Kagenyi versus Musiramo and another. Kagenyi versus Musiramo and another. 1968 East Africa, page 43. The gist is this: that a transfer is not even possible if the court originally had no jurisdiction. The decision of the Supreme Court, or even the Constitutional Court before, are to the effect that from the word go, the General Court-Martial had no power, had no jurisdiction. So there was nothing to transfer. That's why I want you to contextualize the decision of the Supreme Court. Finally, my lord, on the question you did ask me, when we say that you be pleased to order now, The word normally used by lawyers is extempore of judgment. Oh, actually, I'll come back to this. The word is, it is usually used to describe an oral judgment, including reasons for judgment, given at the time of the hearing. That is the context of we propose and implore you to find pleasure in ordering release now. But this particular case of Kageni versus Musiramo was cited with approval in Rose Wanjiku Njau, Rose Wanjiku Njau versus Nicholson Philip and 2 others. Miscellaneous criminal application number 387 of 2012 by the Supreme Court of Kenya. To sum up, my Lord, in one sentence, the affidavit of Mr. George Karemera, which attaches a letter purportedly by the principal judge, and now you can see the bad faith, exchanged without reference to us, particularly those of us who went to the Supreme Court, does not place a lawful justification. It only talks about the administrative measures.
For the benefit of our media house,
Yes, my Lord.
just give the essence, because you have read the stuff later.
Yes, my Lord.
The essence of the honorable principal judge is what is it in principle? Statement.
My Lord, in principle, the Honorable Principal Judge is communicating measures taken by the judiciary administratively to guide the process of moving these files away from the deceased court-martial.
Let's relate those measures. We can speak about 3 measures in a bullet form.
No, my Lord. The principal judge, the Honorable Principal Judge does not bullet those measures.
I'm talking about bulleting in our...
I'm avoiding the bulleting because I'll be reading into his letter, but I can read it. I have received, right to the Minister of Defense and Veteran Affairs and to the Director of Public Prosecutions, I have received the attached self-explanatory letter from the Honorable the Principal Judge, Justice, the Chief Justice, advising that files pending before the General Court Martial that were subject of judgment of the Supreme Court and in the captioned case be handed over to the Honorable Principal Judge for further management.
Bullet number 1, all files go to...
Yes, yes. This therefore is to bring...
Hold on, Honorable.
Yes, bring them to the Principal Judge.
Next.
The next is, this is therefore to bring the advice to your attention for your appropriate coordinated action.
Request for coordination. Second.
Yes. And it is a letter dated the 6th of February 2025. My Lord, even the Principal Judge's letter does not talk about the persons in custody. So it is not telling them continue with the detention. In other words, there is no single order of a lawful authority to detain. And it is that order which would have been the justification to restrict somebody's freedom. Now let me ask a question and answer it. Thank you, madam. That's so gracious. On whose orders and under whose authority are the applicants in detention? Number two, what is the criminal case number? The Supreme Court having said the prosecution ceases and with immediate effect by 31st. By 4 of night 31st, the criminal case number for the General Court Martial ceased. The file could be there for investigation purposes. You and I could be, maybe not you, maybe I could be under investigation. God forbid, you should not. We need you. So the question is, under what criminal case number? And detained until when? The last time we had a detention which is unlimited in duration was under the Public Safety Act. And that one collapsed with the coming into force of our constitutional regime. Nobody can be detained indefinitely where there is no pending charge. That one will be a recipe for chaos in our country that anybody would detain. With that, my Lord, I can only say that let nobody drag the judiciary into this detention controversy of, say, relying on the order, the letter of the principal judge, an administrative letter.
But courts are already dragging. I mean,
very unfortunate.
Ironically, we cannot run away from being dragged in.
My Lord, if we are going to construe this as authority, the letter of the PJ, the next thing they will request you for a letter of granting a warrant to detain. And this was not a judicial letter.
I understand.
It was an administrative guidance to those persons, if they are still interested in prosecution.
I get you.
Anything beyond that, my Lord, is a persecution, and I would invite you to put a hold on it. I so pray, my Lord.
You know, the lady has been standing. I'm not really the lady's lawyer, but I'm the lady's.
My Lord, in a minute.
You are my husband and giving you one.
My Lord, in 1 minute, Sam Muriendo is my name. I'll just take you to Article 43 of the Constitution, my Lord, where you cannot detain anyone without trial. There is no ongoing trial, my Lord. Secondly, everything about that defunct General Court Martial was nullified. We cannot continue discussing putting something on nothing, my Lord.
An administrative letter.
And an administrative letter, whether by the Chief Justice or Principal Judge, cannot be such authority to take away this provision of the Constitution, my Lord. My Lord, further, my colleagues have submitted about Article 123, my Lord. If you look at 123B, my Lord, actually, my Lord, to conclude on the letter, to correct my statement. Our statement, when I look at this letter, it is by Chirioba Chiwanuka, not the PJ.
Actually, I apologize because I got a soft copy. I've only seen this physical copy, my Lord. I withdraw the reference to the PJ, which is the Attorney General. I only got a soft copy here.
My Lord, to conclude, reading Article 123B, even the DPP Even the DPP, my lord.
Hold on. When you say the letter is by
Kiyowa Kiwanuka.
you mean the Honorable Attorney General?
Yes, my lord.
Honorable by designation.
Honorable, my lord, honorable by designation, but I knew that this court would take judicial notice of that, my lord. Finally, my lord, my reading of Article 123B actually precludes the DPP from even taking up any matters from the court-martial. It is very explicit. So most of the submission and the affidavit evidence that I've seen from the Attorney General is misconceived to the extent that it believes, the Attorney General believes someone can be in detention on orders of the Attorney General. My Lord, I join issues with my colleagues. Probably the rest will come in rejoinder. I'm obliged, my Lord.
Thank you very much. I think that's about all from the applicant. Except I also wanted to express a little bit of concern. There's been a lot of scoring this court, particularly my student family. I mean, we love it when people express their minds, but you have to do it. Don't care. Well, if I'm short, I die once and I will be buried, but then you will not have gained anything. So probably your client's matter would have gone before another judge and it went the whole back. Yeah. So appeal to your audience. Tone it down. That is benefit. Fortunately, I don't state the line that if you insult me, then I will take you on TikTok. So I love people to. They can insult me the way they want, but don't extend those insults. Threats. Thank you. Okay, that's about housekeeping. I hope the point is made. AG, can we listen to you? I wish the AG would have time to see it, and then the will be able to speak.
Okay, my lord.
So, AG, have you replied to the application?
Yes, my lord.
So you listen to the comments and
Yes,
the arguments. Can you take us back point by point why you oppose the application?
My lord, for record, again, I'm John Square, and I'm the senior state attorney. My lord, the application before you is for habeas corpus. And for habeas corpus, it has elements that you must prove for it to be granted. One is that the person or the applicant was arrested. The said applicant is in detention, whether by state or anyone else. And that the detention is illegal. It's not in contention that the applicants were arrested and are in detention. The only issue is whether their detention is legal or illegal. And it is our contention that their detention is lawful. Your Lordship, we are not here to review the Supreme Court decision.
Okay, let me go slow. I have to. So we are on the lawfulness.
Yes.
Point number one, bullet one is this court cannot review the Supreme Court decision.
Absolutely. And this is not the purpose of this application. The Land Honorable Chief Justice wrote about 200 pages, elaborate judgments, and it is self-explanatory. And it's straight law, my lord, that any person who feels the application or the judgment of court cannot be construed in the way they feel it should. They applied the same court that issued it for clarification. My Lord, I'm not here to impose words, interpretations, because I'm not qualified to interpret the judgment of Supreme Court, otherwise expressly.
No, but as a lawyer, you are trained to interpret.
Yes, and that's what I've said. I'm not here to interpret it otherwise as expressly given. Your Lordship, my boss, the Lord Mayor, who is part of this government, has elaborately read through the orders of Supreme Court. And if any case would be on my side, defending government. He has elaborately read through the orders of court, dot by dot, word by word, and nowhere did the court say release. It only gave an order of transfer. Transfer all the files which are pending before the court martial to courts of civil courts. And from our affidavit, deposed by Mr. George Karimera, the Land Commissioner of Civil Litigation, he has ably indicated to you steps taken from 31st of January, when the judgment of Supreme Court was granted. I will not go through all the steps taken, but I can only take a brief that on 31st January, the Supreme Court indeed gave that judgment. Most importantly, the court ordered that all charges, all ongoing criminal trials, all pending trials before the court martial involving civilians must cease and be transferred to the ordinary courts of law with competent to fulfill and implement the orders of court. On 3rd February, government commenced the implementation. We wrote the Chief Justice, the Land Attorney General wrote the Chief Justice, requesting for a liaison contact on how transfer of files can be managed. On 4th February, the Chief Justice appointed the principal judge as the liaison contact and instructed him that all matters should be handled by himself.
So, if I now sit here trying to listen to these comments, I will have superimposed myself on the role of the principal judge.
I'm coming to that, my lord. However, I didn't want it, push it into your mouth.
No, you can, the way you
But
want.
since you have already said it, my lord, I take it, and that is the position of the respondent. And on 6th February, my lord, the Attorney General forwarded the Chief Justice's instructions to Minister of Defense and the Office of DPP. And on 13th February, that's when we received a decree from the Land Council for the applicants in the case of Carol, in the case of Attorney General versus Carol. And on 17th, the same was signed by both parties. My Lord, Article 28 refers to fair hearing and a speedy trial. Speedy trial and fair hearing is not one-sided. It is both parties. In this case, the applicants and the state. The state has taken action to implement the orders of court. The orders of court are clear to transfer the file. And it's not in contention that indeed the applicants had been charged at court martial and they had been remanded and there was a warrant for their remand. If the Supreme Court wanted to cancel the remand warrant, wouldn't have taken a paragraph after almost 200 pages to mention so. It only said transfer the file to ordinary courts. And that's what the state is doing. It will be contempt of court.
Of this court?
The Supreme Court. For this court, for the other ones. And also, if Attorney General had not acted the way he has acted. The fact that the Supreme Court ordered transfer and did not nullify or order release all the accused in the court martial. And for your information, my Lord, it's not the applicants alone who were before the court martial. There are many. The fact that there is no order on court people. I have heard my land senior colleague, Honorable Segona, trying to explain what is not in the judgment of the Supreme Court. I don't know whether we have different copies of the same judgment, but there is nowhere where the Chief Justice said otherwise, apart from transfer. And if he wanted so, he would have done so. The fact that the Supreme Court did not say release, it was aware of what it was doing. And in that so, it validated all the orders that all the suspects are based on to be in prison. If it had been otherwise, a sentence of saying release, actually that word alone, release, would have been enough. But if there is any party that misconstrued the judgment of Supreme Court, the right forum is the Supreme Court. As an office of this court, Honorable, and it guided that you will not be misguided by my land colleagues from the other party.
Just to quickly correct you, it's not likely that a judge can allow that.
Most surprised.
That's why we are judges.
Most surprised. And I'm alive to the fact that you are a doctor in law.
Okay, let's not go there.
You will not be misled. So the aggrieved party in this circumstance, my Lord, for the interpretation of the Supreme Court decision, to go back to the same court that issued the same order, what it meant by saying this.
I get you.
It is in the interest of the state and for the people of Uganda that justice is done on both fronts.
I think what the lawyers on the opposite side are saying, okay, fine, we are doing something. For how long must this wait take place? And you want to address that?
Yes, my lord. I will not accuse the Supreme Court as being to give us a time. But however, from the reading of our evidence, the judgment was given on 31st January. Immediately, on Monday next week, which was Friday, we acted, and the process is ongoing. We are not going, I cannot mention how many files are involved, but they are numerous. And the process of expediting the process is on course, and that's why the principal judge was allocated this responsibility. It would be premature.
So if there is an allegation of slow speed on your part, it is because of the volume of work you have to handle and not that you are deliberately.
And it would be injustice, my lord, to say that it's slow speed. For example, this application was served on us last evening around 9 p.m. There is an affidavit on record.
Yes.
I didn't sleep. My team did not sleep. The Attorney General did not sleep. I was on phone up to midnight to respond, to ensure that justice is served on both fronts. My lord, in conclusion on my part, this application is conceived because the applicants are aware that they are in detention legally, and the state is not denying where they are. And at any time we want to look at him, we can even visit him, anyone can visit him. And if anyone wants to be produced in court, can be produced in court. But ordering his release would be in contempt of the Supreme Court decision. I saw submitting.
My lord, just in 1 minute. My lord, I would like to associate myself.
Your names again?
My name is Jackie Amsugu.
Yes.
I would like to associate myself with my colleagues' submissions, but I just want to emphasize that as has been rightly submitted by my former teacher, my Lord, Council Kalibala, that yes, one of the orders, one of the conditions has been fulfilled, and that is the production of the applicant. Now, the other issue would be the lawfulness, or whether or not it is in illegal or legal detention. My Lord, I want to emphasize that we should not read into the judgment of the Supreme Court what it did not provide. This was a decision of the Supreme Court not sitting as an ordinary court, but as a constitutional court. And my Lord, as the highest court of the land. Now, my Lord, as officers of the court, we need to respect court orders. And for the applicant to come to this court and read into the court's decision that the warrants that were given by the court-martial have been invalidated is a very serious misconception, my Lord. Our submission, my Lord, is that the applicants are in lawful custody. And why am I saying that? I would like to make reliance on an authority of R versus Governor of Brixton Prison.
Instead of going there, why don't you discuss Ibingira? Because your former teacher said Ibingira was where he was no. But the court went ahead to say, no, it is still illegal.
In fact, my Lord, I am trying to justify that we are holding him or holding the applicants in a lawful way, or we are having them in lawful custody, supporting what my teacher has said, that we should justify that we are holding him in lawful custody. And in this decision, my Lord,
repeat the decision.
It's called R versus Governor of Bristol Prison of Pate Ama. My Lord, the House of Lords was examining whether a detainee held under extradition proceedings could be released via habeas corpus, despite procedural irregularities. The court held that even where there are procedural errors, detention remains lawful if there exists a valid substantive basis for the person's confinement. The emphasis, my Lord, is if there exists a valid substantive basis for the person's confinement. My Lord, this is the valid.
Do you have that authority?
Yes, my Lord, we supply it to the court. Now, my Lord, in this case, Dr. Kiza Besigye, or the applicants here, were arrested and charged with various criminal offences, including treason, my Lord, which justifies their pre-trial detention under Ugandan law. The fact that this case was initially handled by the court-martial does not negate or does not invalidate that we had valid reasons, my Lord, to detain them. And my Lord, the Supreme Court, well aware of this, simply said, transfer them to the civil court. Our submission, my Lord, is any argument about the warrant being not valid can only be made after the process of transfer has been completed. And this will happen before the criminal court, which is going to handle his matter. My Lord, it is very misconceiving and misleading for this court handling a matter for habeas corpus to go into questioning the validity of the warrant, which is the basis for which the applicants are saying they are holding him illegally. My Lord, that is not the purpose for habeas corpus. We are praying, my Lord, that you be persuaded by this decision. And my Lord, we have highlighted the relevant facts, and you will notice that the court said,
I can return it because we are.
the court actually says that you should not question, that the question then arises, what should be the proper approach by the court in determining any such inquiry it may make. Of course, the authority on which the lower holds the applicant is the authority of the court. The court-martial was the court at that time. Can only, and it is still the court, can only be to see whether the court, this is what this court says, can only be to see whether the court had facts before them, entitling them to issue the authority, the warrant. This is what we are telling you, my Lord, that we had valid reasons to detain the applicant. So to argue right now that the warrant is invalid is not proper before you, my Lord.
Wind up.
And on that basis, my Lord, we pray that this application is dismissed for being premature. We have clearly stated to you through the affidavit of George Kalemera the processes that the Attorney General has taken in compliance with the orders of the Supreme Court, not outside the orders of the Supreme Court. My Lord, we pray that you are persuaded by our submissions and this is his application to process.
The Honorable Lord Mayor, you want briefly, how many minutes should we give? At least we know the complaint, we know the argument.
Yes, my
We
lord.
shouldn't repeat what we already know. So you can highlight maybe in 3 minutes what you
In
really
5
want
minutes
this-
I'll be done, my lord.
Okay.
Most obliged, my lord. One, my lord, on the contention that the applicants are in lawful custody. My lord, we are really disturbed by the justification given by the senior state attorney here, reading too much into the Supreme Court decision. Is suggesting that by ordering the transfer of the files, by extension the remand warrant was extended. That is, if I got him well, correct. That is an absurdity, my lord. He reached a point of suggesting that if court held otherwise, it would amount to contempt of court. If this honorable court held otherwise, that it would amount to contempt of court. We take exception to that, my lord, on the following grounds. One, my lord, the Supreme Court was categorical in its directions. And if they wished in any way to save any order of the defunct General Court Martial, they should have said so. If in any way they deemed it necessary to keep the applicants on remand pending transfer of their files, they should have expressly stated so. It's nowhere stated in the orders. My lord, the Supreme Court went ahead to give structural interdicts in regards to areas of amendment to guide the Parliament. If they could go out of their way to guide the Parliament, if they have come up with a new legislation, the parameters, the principles, how about on the issue of remand, if indeed they wanted the applicants to remain on remand pending the transfer?
Okay.
That is one, too.
No, before you leave that,
Yes.
you know, the way I understand the structure interdicts, the court will say you have to do A, B, C, D within 6 months or 1 year. If you don't do it within that time, we shall do it like for you, and the wording shall be like A, B, C, D.
Yes.
That is how I understand the structure here. Is this what the Supreme Court said?
No, that is for the legislative process. There was structural interdicts. But if for declarations, my lord, they have to be contextualized within the existing constitutional order. Now, for the transfer of charges and files, they have to be put within the context of Article 24, rather Article 23 of the Constitution. And I'll read it. Article 23 and I'm being bombarded. Article 23, 4B, the 48-hour rule. That anybody whose rights are whose liberty is restrained shall, if not earlier released, be brought to court as soon as possible, but in any case, not later than 48 hours from the time of his arrest. My Lord, the Supreme Court decision should be read in that context. That actually the Supreme Court did not purport to overthrow the Constitution. They couldn't do so. So if the state wished to continue with the prosecution of those cases that hitherto were being handled by the General Court Martial, the time frame is set by the Constitution, 48 hours. And in lawful custody, I don't want to give them the advisory, but if I were to go there, what I would do immediately, you would get them from prison within the 48 hours, take them to police, in police custody, because you will be then be breaching section 37 of the Prisons Act to keep them on remand without a remand warrant. If I may ask, my Lord, the prosecutor, I mean the state attorney is justifying the detention.
So are you asking the court so that we give you the answer?
Okay, let me give the answer here, my Lord.
No, it is okay. You can ask and we frame it as a question.
Okay, let me frame it as a question, my Lord. Are the applicants right now on remand? Are they on remand? Pending what charges? If they are in custody, pending fresh charges being preferred against them.
You have asked two questions in one. The first question is, are the applicants on remand right now?
Right now.
If so, what charges are they facing?
Exactly.
So you continue. So that's
yes, what charges are they facing if they are on remand? And if I may add another question to that. If indeed they are awaiting transfer of their cases or charges for that matter, in the affidavit here they are indicating those charges, those matters are being handled by the DPP. And my land colleagues here have cited Article 120 of the Constitution, which bars the DPP from sanctioning files before the General Court Martial. Has the DPP got anything to do with those charges, which were hitherto being handled by the General Court Martial in the context of Article 120? Even if they were to be transferred, has the DPP got anything? And finally, still on that question, my Lord, when you read the affidavit of Karemera, the Attorney General is simply saying that he wrote a letter to the DPP and the Minister of Defense. He is not indicating any action taken.
Okay, the question would be, is the Attorney General's letter,
yes,
the DPP, indicating of any action is taken? Or does that letter indicate any action is taken? I want to record your question, because I have to answer it.
Most obliged, my Lord. Does it in any way address that? And in any case, my Lord, in section 10, the Attorney General Karemera says the Attorney General's chambers forwarded the Chief Justice letter to Minister of Defense and the DPP advising that the files be forwarded to the principal judge. The Attorney General simply states that they acted as a conveyor belt. They received the letter from the principal judge, forwarded it.
Can you frame a question on the conveyor belt? Because I have to answer you.
I wanted to advance an argument in this, because this is my construction of my understanding of this.
Okay. The question would then be, was the Honorable Attorney General acting correctly to do ABCD? I don't want to use the conveyor belt.
My Lord.
Okay, sir. calm down. Calm down.
Position here, if you check.
We note that there was a 4.1% decrease in the number of crimes reported to police from 74,000 cases in 2023 to 218,715 cases in 2024. I take this opportunity to express my sincere gratitude to our people who were able to lodge in their complaints at the various police stations and units in 2024. It is these reported complaints that enabled us to compile this annual crime report and be able to assess progress